gather around. We're going to get going here tonight.
Okay, thank you so much for coming. New location over here. The other one was preoccupied with Cal Poly students, so we're thankful to the Wayfarer for having us. And we have a great panel of attorneys tonight. I see a lot of new faces in the room, so I'm very excited about that. I think you guys know that we bring the value, and these guys, we are already grateful for you guys showing up because we know you have very valuable time and limited time. So we're grateful for that. It's Ann Wilson, correct?
Yes.
And then Brighton Hushing Klein, one man. Yeah, 3 names, 1 man. I'll let him get into that later. And then my co-host Owen, and we've been doing this for a little over 3 years, and we do it every month. Lately, we've been doing it on the second Tuesday of every month, 6 p.m. to 7:30. Sometimes it runs till about 8. And we definitely encourage networking, sharing numbers, sharing deals, partnerships, and we've had plenty of deals come from these rooms, so it's pretty cool to see. Anything you want to share?
Yeah, the SLO Real Estate Investor Meetup, we built this group with the mindset that we can achieve more together, especially if we learn from each other, we share each other's contacts and network, and we've seen that happen. I mean, it's so encouraging to hear people who came to this group, they didn't own any real estate, and then they bought their first rental property. Now they're house hacking, and they're looking for their next one. So just by being here and meeting people, it's going to rub off on you. You're going to get the bug for real estate investing, and we're excited for it.
Yeah, and I think we've done polls like, just raise your hand real quick if you have an investment property or you own property. So, I mean, that's pretty active right there. That's awesome. That's active investing. So, without any ado, I'll let you guys take over, and we'll kind of chime in with some questions. We didn't have like a set question, so if you guys want to cover a topic that you're passionate about, we can go that route. And then if we have questions, we'll just kind of fill them in.
Yeah, so start out, share a little bit about who you are, what your bio is, and then we'll kind of open up with a couple questions.
Okay. Hi, I'm Ann Wilson. I came here in 1988 with my husband. We practiced law as husband and Wilson and Wilson. And he retired, and then I joined the firm of Carnell and McCaution because I still had all these clients and I was having fun. So that's what happened. I have been focused on real estate law pretty much from the beginning. And I'm a member of the Legal Affairs Forum for the C.A.R, California Association of Realtors. And I don't know, that's basically my background. So we're starting with that.
Sweet. And can everybody hear okay?
Mm-hmm.
Yeah. Awesome. Good. All right.
And you do kind of like talk.
Yeah. Well, I had a grandfather who was hard of hearing, so I'm pretty good at projecting across the room. Hello, everyone. My name is Brighton Killian Hushing Klein. Yes, 4 names. The best way that I think I can introduce myself is when I was 6 years old, living in Atascadero, California. I was a very precocious kid, and I would answer the phone. Hello, Hushing Klein residents. Brighton Killian Hushing Klein speaking. And I won't lie to say that on more than one occasion, they're like, oh, I'm sorry, I was trying to read it. So resident, what did you say this law firm was again? And so I'm a local. I came here when I was 5 from East Bay, and I made my way up, and I took up, I did some work with a debt collection agency in Paso Robles, GCFS, and then I started working with Glenn Lewis in Atascadero, and I took over his business. And I was worried that my name would think I was a multiple attorney incorporated agency, so I call myself Hushing Law, just to keep things simple. And I do unlawful detainers, a lot of estate planning and trust litigation. So getting property untangled out of that wonderful cesspit we call probate and trust issues, especially with underfunded trusts. I spent a lot of time there. There's a lot of very interesting stories about those situations that I don't think I can tell yet.
Okay. right. So this is a room filled with people who are investing in real estate or who want to start investing in real estate. So thinking about the audience, what would you say are some things that a real estate investor needs to be cautious of when going about acquiring property here on the Central Coast of California?
Loaded question.
Have a good rental agreement. It depends on what sort of investment we're talking about, because if we're talking about flipping, you have to make sure that you are able to get a good enough return on investment before you put it around. But it's a renter's market, and with interest rates being what they are, chances are sitting on a rental may not bring what you're holding. But if you are going to rent, and I'm sure Ann will agree with me on this, make sure you have a good rental agreement. One of my favorite stories has to be there was this on actually just a couple blocks from here on Grand Avenue. There was a house, and I was talking to the owner, and he said, "Oh yeah, could you look over my lease for me?" And I'm like, "Sure." And I looked at this one page, and I said, "Why is there a passage here that says you shall not lift or throw any goats, sheep, ungulates, or other animals from the roof into the adjoining pool?"
I used to live at that house.
And needless to say, it was a Cal Poly house, and Cal Poly students were out to try to figure out exactly what they could get away with because it was a party house. So there's a lot of experience in this room, and get people's bad stories, because the thing is, the vast majority of renters you're going to deal with are just good people looking for a place, but that one bad renter, if you're not prepared for them, will buy every single previous renter, and you'll never look at them the same way.
I spent the afternoon with one of my personal tenants, and she's only been in there for 3 or 4 days. Police were called, ambulance was called, the place is stuffed with junk, and I mean, my partner is a retired real estate attorney judge, so we have a pretty good agreement, and we got down into like in the premises or on the premises. We were arguing about that. So the good lease is very important, and don't get one off the internet. The C.A.R. I mean, some of them I take and then revise them. The good thing about the C.A.R. forms is that they go through a lot of vetting before they actually are out there in the public. They go through the real estate agents, they go through the legal affairs forms, so practicing attorneys can give opinions on them. So most of those forms, some of them are really stupid, but many of them are usually well vetted and therefore pretty good. Leases have to be, I revise them every time we have a new tenant. Because the law has changed so much since 2020. If you're buying property, it doesn't really matter the purpose for your goal in buying that property, but be very aware when you're looking at the property, both like on the title and just looking at the property. There could be things that are out there that aren't advised. I have a client who is a foundation that is like very zen, and they ended up buying property that was a former cannabis grow, and there were all sorts of problems, and they didn't really realize that maybe you should ask questions about the grading. You should ask questions about the creek and any changes to it. There's a lot of investigation depending on the type of property that you're buying that you will need to look at and ask questions about. And you never know until you're at that property, but just keep your eyes open. Whether it's a document, whether it's the property itself.
get a title report.
Okay, going in,
Share it.
Oh, jeez.
with that in mind, did
We
you?
have a case together which very centrally issues a title report, which they were just so nice to get to me and saved us a lot of time. So
Do you guys use car leases, or do you have that and then you add on to that, or?
I take like a few of them and put them together.
Okay.
And then, my other partner, he's a little particular, being a judge. So, I have to do what he says. But so it's like the two of us put it together. But I start with the car form, and then the American Apartment Association, I think it is. And then you take all of them in our prior ones.
what I will say is that we help you legal, American legal. These I call income generators, because I have never seen a client that has gone to one of these places for any substantive legal document, and they haven't made me a couple $1,000s. So the only reason to go to those places to get stuff offline is to have a form to begin with. And CAR is never a bad place. Most of my forms start with CAR. I have a lot of clients with very, very, shall we say, idiosyncratic needs. There's farmers and people with farming leases attached to their property. So I have to do a lot of, shall we say, embroidery on the edges.
Okay.
But even if you've just got a run-of-the-mill lease, do not trust online sites. Do not go near them. The best they can give you is a notary if you need one. But like all these self-help places, they've never failed to generate money for me, ever. Just
unless it's a reputable. I mean, there's the AIA, C.A.R. I mean,
Yeah, see, we have your yeah. Oh, are you talking about AIR or like air forms?
Yeah.
Yep. Okay.
Sorry.
Okay, so to go into that, this will probably lead into that, is if you have a poor tenant agreement or a lease, and you're trying to do an eviction or get that tenant out with today's law, which is always changing as we've noted, how would we go about that, and what would be the process? And then, by a show of hands, who has had a tenant issue in the past? Not eviction, but just a tenant issue in the past, with someone not paying or someone late,
Violating the
like
lease.
Yeah, and then who's actually done a full-fledged eviction? Okay. Yeah. Okay, so let's go with that, and we'll kind of go back and forth.
just to do these things up, or
Sure.
Unless you're really, really familiar with the current law on evictions and all of it goes with it, I would hire somebody, either a property manager or an attorney. And like as of today, after spending the afternoon with the tenant, I would think, God, property manager would be great. They would be over there. But we're handling it ourselves, but it is not easy. I mean, it takes time. It takes time that you're not even there physically with them, but just like I wanted to strangle her neck. And, but I did a little criminal defense work, and so I know it.
Yeah.
My partner was a criminal defense attorney. So I would not do it yourself unless you're ready to just like have a crash course for a month to go into a courtroom. And I mean, if you start it off wrong and then you go all the way through, you could be in front of the judge finally, and then the judge, especially first, would go, she'd go, well, you didn't do this 3-day notice, right, because it didn't have a comma in the marketplace or something. Almost literally. And so you have to be very, very careful about evictions. Yeah.
one of my clients failed to put the area code on the phone number on their 3-day notice, and the entire case got thrown out. So we are talking about hyper technical interpretations. Now, the judges will mandatorily put us towards mediation. You can get away with some things in mediation that you can't do in court, but if you absolutely have to go to court, I mean, the easiest response is, if you want to do it yourself, don't. There's an old saying, a lawyer who represents himself has a fool for a client. And if you're not even a lawyer, that's just double right there. But one of the things is, if you're going to begin eviction, you either have an attorney write up your forms for you, or you make darn well sure those forms are updated.
We can share my story.
Okay.
So like, I thought, like, we've done plenty of 3-day notices. We haven't gone full term eviction. Normally when you send that, like you said, they're gonna pay or they're gonna leave. And basically we gave them a 3-day notice, waited for the 3 days, got no response. We sent you the 3-day notice to review, and you noticed, you can share that part.
There wasn't a phone number, and the change in the unlawful detainer law is not only do you have to have a contact place and a place to pay, but you need to have a phone number to contact the landlord. I ran into this when it first went in, and one of my older forms got used, and that was one of those situations where I had to dance real fast in order to keep the person out. But if you absolutely have to do it yourself, make sure you at least spend some time to consult with someone who knows what they're doing, because the judges don't care about how bad the tenants are. They don't care. That's not their business. Their business is if you have exactly and specifically followed every step in the procedure and the process. And the problem is that there are enough landlords out there who pay lip service and ran roughshod off the tenants that these judges are very, very, very gun shy. They won't believe, oh, I made a mistake. They won't believe, oh, I'll just fix it. If the tenant comes in and swears on the Holy Bible that, yes, I knew about this, I got 3 copies, but your proof of service and the copy of the notice that you filed in court are not correct, you're going to have to start over again.
And the whole landlord-tenant law has evolved because there are terrible tenants out there and there are terrible landlords. And when you have 2 groups of terrible people, it results in terrible law. And that's what we are.
Wow. I think that was the example you used, right? You're like, you could actually text your tenant the 3-day notice that you have, and I didn't have my number on there. And and they would still throw it out because even though they had the number literally that I sent it from.
That's ridiculous.
Yeah, it's pretty crazy. But
It's the thing is that so many people skirt. They take shortcuts. No, don't take shortcuts. Shortcuts, they lead to so much money I have made off of people who've taken shortcuts. And I mean, I like money, but I feel bad when a person comes into me and they say, oh yeah, I spent $1,000, I got all this stuff, and I tell them, just throw it in the trash. It's worse than having nothing at this point.
Wow.
And honestly, I would say it's probably better to pay the tenant to leave. It's going to be easier for you to just pay them to leave if you can get that to happen, than to go through the eviction process.
Absolutely. I
yeah,
agree.
good question in the back real quick.
Yeah, so assuming we're working with one of the softwares themselves, like what the typical timeline from start to finish, assuming it goes its full
Good
term,
question.
and then I was like a range, but like the ballpark, and then same thing like as you're penciling in those costs, what is the ballpark?
Well, not all results are indicative, and costs are subject to change depending on the circumstances and the contact. Generally, if it's a default situation, there's just the cost of filing and the initial things, and it'll probably be resolved for less than around $1,000. But the problem is that there are several stops, because right now I call it my universal 360. If you're even going to go with a client on a 3-day notice, you also throw down a 60-day notice if you can at all justify it, or a 30-day notice. Because you never know what's going to go wrong with that 3-day notice. They can claim, oh, I've complied with it, or oh, I did this, or they lied about my compliance with it. And then you get into a factual dispute with them. And factual disputes is where I make my money. So we have the notice. And then once you file, it depends on whether you use a prejudgment claim to right of possession. That's a very fancy way of saying, did you bring any squatters into my house? And if you do that, that pushes it back another 5 days. And if they file an answer, then you have to schedule a court appearance. I've had some success with motions for summary judgment, which can be done on 5-day notice, so you don't have to wait the full 2 weeks for it to go to trial. But in a case where there's an actual factual dispute, we're talking about what, a month?
Yes, and then you have the delays with the courts and the sheriff. So even after you get a judgment, so you show up, you're in court, you get the judgment, you go yay, and then you have to wait for the paperwork to come and all the various, the writ and all of that. And then you have to take it down to the sheriff's office, the civil division, and they have to have it by Wednesday or before Wednesday, because they go out and serve them on Wednesday. So they go out and serve the tenants on a Wednesday, and they come back the following Wednesday and kick them out. So it's so even that can take an additional 2 weeks because of the timing. The court is very slow, especially in Paso. And then the sheriff has just every Wednesday. So if you miss that Wednesday, like you get it Wednesday night. Yeah.
What happens if they don't leave?
Oh, that's fun. Actually.
Oh yeah.
So I've been out there when the sheriff actually shows up, and they sit there and they go, yeah, we're sorry, you have to go, and they make them take everything out, depending I think on the sheriffs themselves that you get, and how much time they have. I mean, I've had them where they do the kick out, and they're not. I mean, there's still a bunch of crap in the house, and so then you have to. Then they go to somebody else, and then they come back, but they are there. They will. You have to have the locksmith with you, but they will make sure it's all out. Yeah.
So you're saying your alternative to that is just pay them to get out versus going through all that, and we just the 2 months rent.
Well, you offer as little as you can get away with.
Yeah.
Yeah, it's a negotiation. There's no set. I have a lot of people ask me that. You know, what's the set amount? There's no set amount. It's like what you think both sides can get away with. You know, both will be equally unhappy.
In the Bay Area, there's some more like strict rules, and you have to give a certain amount. Like one time, family up there had to evict someone. It was like $13,000, and that was cheap. We've heard of like people having to pay $60,000 for keys. So, like if people know the system and the rules, like tenants can like work the game and play it and like stay for a long time, not pay rent, and then you have to pay them to get out.
Right.
Tenants don't tend to have a union. They have bulletin boards and online spaces. A great way to figure out what, if anything, they're going to be asking for is, you know, if you have some time and a huge capacity for, as they say, rage bait, you know, figure out if there's a local bulletin board of tenants in your area to see if they're discussing, I got this mount from my landlord. Actually, a quote that I found off of a defendant on one of those sites is actually one of the quotes on my website. I was litigating against this guy, and he says, "Oh, that's right. He'll throw everything, including the kitchen sink, at you." And I'm like, "That's a great quote. I'm going to take that."
Nice. So when doing an eviction, there's the 3-day notice to pay rent or quit if they're in default. They haven't paid on time.
In
payment. And then at that point, I like what you said. You give the 60-day notice at the same time you give the 3-day notice?
Yes.
So does the 60 days start from the day you've
They count down from the same day, which is why you serve the 60 days as soon as possible.
Sweet.
And one of the things and this is one of the reasons why I'm always saying you have to keep your forms straight. Because I had a tenant and a judge who said, well, there might have been a possible overshadowing. Overshadowing is when you serve a document that kind of implies that another document you serve isn't effective anymore. Like if you're doing the battle of the forms with someone on a real estate offer, and you send an offer and they send a counteroffer, the counteroffer overshadows the offer, so the offer is gone. But I had the foresight to write in here, please note this does not revoke or change any previous notices. This is in addition to any other notices. I pointed it out to the judge. The judge backed down. The tenant made some noise, but we were able to get the tenant successfully out of that situation.
And it's things like that because after you've been doing it a while, you know how to do these games, sort of. And if you're just learning it from a book, you don't have that experience and, sometimes stumbling yourself. So that's why it's important, I think, to hire somebody to do it.
The language of the law is not logic, it's experience. Was that all over the whole?
Nice.
I'm stealing quotes from great jurists.
These
so
are
don't
great
listen.
quotes. So the Tenant Protection Act recently came out into law. It's kind of made statewide rent control, and you have to have just cause for eviction. So we've been talking about evicting for not paying rent, which obviously there's just cause for that. And then let's talk about some other reasons why you could have just cause to evict someone for like breaching the lease. What does that look like, and is it the same process?
It's sort of the same process because you have the 3 days to cure or quit. And so that too, and when you do that, and then you have to give, if you're doing a cure or quit and they don't cure, then you have to give them another 3 days to get out of it. Yeah.
If you forget to do the 3 day to quit after the 3 day to cure or quit, they will wait. They will wait until the absolute last day, and then they'll go, oh, I fixed it.
Oh.
And then you have two choices. You can either give it up or you can, no, you didn't. And, if it's a marginal issue that it's not really conducive to being very clearly proven to someone who is 20, 30 miles from the unit you're trying to clear out, then people like me get paid a lot of money for that sort of situation. And there's no guarantee that even if there's objective proof that they haven't cured it, that you're going to prevail. The judge may just say, well, there is some dispute, but I don't find enough evidence to sufficiently justify removing the tenant. That's the thing, not sufficient evidence. And this is all based on the judge. This is Glenn Lewis, the attorney I took over for him, always said, it doesn't matter how good your case is, you're always flipping a coin the minute you get in front of the judge.
It's worse in front of the jury, though. But one of the cases I was most proud of actually was during COVID. I think it was June of 2020. I had a property where the tenant was dealing drugs, and then hit the landlord. And those are two ways that you could get people out during COVID. It was one of the few UD cases I think that went through there.
Wow. Just happened to do the only two things that
Yeah.
will get you evicted.
I know, yeah. So those are two things that will get you out. Material breach of the lease.
But smoking, for example, a lot of the CAR form says no smoking on the premises. So if someone's smoking in your unit, is that an incurable breach of the lease?
Did you hear me talk about in and on?
Yeah.
It was smoking, and she said it was in the unit, and we said, look at the definition of premises. And the definition of premises was not only the inside, but the exterior as well. So she goes, oh. So, I mean, that's how it gets down to,
So you could evict someone if they're smoking when the lease says no smoking.
I said yes. I mean, we were arguing, my partner and I were arguing. He wasn't sure that was enough. I think it is, because in this area was a lot of people nearby. So it would not just be your area that was affected. It's like several other residences that were around.
But that's less of a breach of covenant and more into nuisance. Nuisance is another fantastic sort of catch-all. When the person is being so disruptive, they are making your other tenants or other people in the area nervous.
Or when the dogs are barking 24/7.
Oh, dear Lord, the
I was gonna
dogs.
get into dogs. Yeah.
Yeah.
Like
And
it says no pets, and then all of a sudden they have a pet.
And it's a
Yeah.
service dog. I'm not going to get into
Yeah.
It's always a service dog. There are places that they can print out service dog certification forms. I had a tenant who had a dog that attacked another tenant, and we were going to say, this is a nuisance, it's threatening other tenants, and and they said, well, it's a service dog. I'm like, oh, okay. You didn't ever provide us notice of this? Do we have any paperwork? I would very much like it to have paperwork, and of course you can't actually ask for it. But I tried to see what I could get away with, and lo and behold, they had a service dog official form dated the day after the attorney told me that the dog was a service dog.
But if you have questions
Oh,
about
man.
those, the
I hate-
Department of Fair Housing, I think it changed names again, but they have an excellent website and has a lot of information on how you can get people out, the protections that people.
The state of California is almost always a good resource for that sort of thing.
And that's a really user-friendly website,
Yeah.
so it's a good source.
What was the website?
It used to be the Department of Fair Housing, and now I think it's the
FHA, the Housing Administration.
But then I think the Equal Opportunity.
And it's California specific.
It
Yeah.
is, yeah.
Is that California landlord handbook that they have and they update every year or so?
That might be what they put out.
Yeah.
But the website has really good.
Yeah.
If you type in DFEH, I think it'll at least send you to the right spot.
Can we talk a little bit more about the cash for keys situation and if there are any legal rules surrounding offering your tenant money to leave, especially if they have not done anything wrong? They're just in a unit, let's say like you buy a property and the units are all way under market rent and they've been there forever and they're paying their rent on time, but you could be making double the rent on that place and you just really want to get a new tenant in to be able to get market rent. Are there any rules about offering cash for keys in those scenarios?
I haven't seen any ordinances.
I haven't either, especially here. I mean, it might be in the Bay Area or LA, Hollywood especially.
That's ridiculous for like remodel.
Renovations. Great
There has
remodels
to be
and
a significant, substantial
There
renovation.
has to be substantial renovation where they cannot reasonably live in the unit during the renovation, and
For 30 days.
you for the love of God, don't try to shortcut it. That is a tenant lawsuit waiting to happen. I know some people are like, oh, I want my family to move in there. Family moves in, stays a week, and then leaves. And then they're making some tenant lawyer very, very happy about that.
Are you guys familiar with the new? I guess this comes into play
April 1st.
Is it April 1st?
Just
Yeah.
happened.
So it's an overlay for AB 1482, which was the tenant law or Tenant Protection Act, and now it states that basically your family has to live there for 12 months, and you have to name who they are, and then it also encompasses the
Rent eviction.
yeah, the rent eviction for the just cause renovations, where if that tenant finds out that you didn't do the actual renovations and you didn't have permits, they can sue for remedy, and they can get basically
Triple damage.
yeah, and it's unlimited. So they could they could say that they were going to live there for the next 20 years, and you would have to pay them 20 years of lost rent, basically.
Yeah.
So,
Yeah.
So, that's why you really can't mess with this stuff.
So
Yeah.
there isn't a description of what exactly constitutes a substantial renovation. Is it length of time? Is it the percent of the property that's renovated?
They can't be. They will have to move out for at least 30 days.
The answer is yes to everything.
And I've been told that you need to get a permit because it
Right.
shows proof that you're doing
Right.
You have to have a contractor specified,
Yeah.
list
Yeah,
of all the
there's a
improvements
whole-
you're doing.
Yeah, there's a lot.
It's
of-
Yeah.
just gotten a lot harder
So-
April 1st.
So I just went to, I don't know if you went, but there was a seminar put on by the local bar on just landlord tenant and the recent changes, and it was an hour, but it just like covered the surface.
Yeah.
So this is an area that's really fraught with.
So to protect yourself, get a permit, have a general contractor, not a handyman, do the work, and the work has to take more than 30 days.
Yeah.
Or at least 30 days.
And it can't be something that they could live in. You can't paint.
Right.
Yeah.
Yeah.
You know, carpet.
Carpet, yeah.
Nothing cosmetic.
It has to be something that the tenant could not live in the
Right.
unit
How
for.
about bathroom remodel? Is that
If there's one
considered
bathroom, maybe, but you should be able to.
two bathroom.
But
That'd be
see, I don't
considered
think that would
substantial.
work because
Yeah.
they could use one and then the other one. And I had one case where it was the tenants had damaged the kitchen to the extent that they had to tear it all out and put it back in. And I was not really confident that that would get through.
Yeah.
I just didn't know. And they caused it and there would be no kitchen. But I wasn't willing to suggest that my client risk that.
Okay, now say if you had a tenant who's paying really low rent, but then you came in and you redid everything in the house, but they're like, hey, we don't want to leave because we love the house. We're like, we're going to redo the kitchen, we're going to redo the floors, the paint, all that kind of stuff. And then, but they were still at really low rent. So say you did it all, and then they, come back in, say you gave them housing for a month or something like that. Then they move back in. When could you raise their rent to a standard? Or you can't.
I don't think you can. And I think the other issue is that
Is it in the still town or they drop it down to
5%.
Oh, it's 5% inflation.
Plus
Yeah.
Oh, yeah.
So you gotta wait.
Yeah.
Right.
Yeah. If there's a continuity of tenant, treat it as the same lease. Doesn't matter what you've done. And the thing is, if you're in any situation where the tenant says, but I wanted to stay, you're stepping on a landmine. It's a situation where the tenant cannot and will not stay. In that situation, I just pay the tenant off. Figure out what they're expecting, what they say, I'll need this to get another place, and then just pay it. That's
You might
probably...
And the other problem with this whole landlord-tenant just cause snafu is that there really aren't any cases that have come out because it's been through COVID. And there's no cases going to trial, and then there's no cases then that are up on appeal. And the benefit of having cases go to appeal is that you have a set of facts. And then the judges interpret the law to those set of facts. And so that's how you really understand how the law is going to be applied. But in all of these landlord-tenant statutes, we really don't have much of any appellate decisions that interpret the law. So we kind of guess that this is what's going to happen, but it's very gray, very gray.
You could be the first one though and set the precedent.
Yeah.
If you want.
Pave the
Let
way
us
for
know.
us.
I have the same tenant too. They've lived there for 20 years. They want to stay there, but we want to renovate. And so you don't think we could move them to another unit and they could live there for 6 months, and then they move back in, but it's a different family member that signs the lease.
Don't get tricky.
There's something about that, and I don't have it memorized.
Okay, yeah, I'm gonna have to look
there's-
into that. So
yeah.
if you find an answer,
I think you have
I'll
to
pay
try and
for
move
it.
them to someplace else first.
Okay.
Despite our confidence, we are not experts on literally everything. One of our talents is to be the smartest people in the room after you've given us 15 minutes to prepare. Maybe an hour. But the thing is that, like I said, like she said, I'm not going to steal your thunder on this one, but the interpretation of the law is based off of cases which have been taken up on appeal to a superior court, and then the judges say, well, here are the facts, everyone's agreed to it, and here's the law. How do we apply those to each other?
Mm-hmm.
And there's three problems with that. One, landlord-tenant law, no one wants to go up on appeal. By the time you go up on appeal, unless you're in some place like LA or San Francisco, it's better just to pay the tenant what they ask for to get them out. It doesn't matter how much, it'll be less expensive than appealing. The second is that because the way these things happen, the frequency and the short time frame, most people just don't want to deal with taking them up on appeal. And lastly, the law is changing so frequently, you could take a case up on appeal now and the law won't be the same 6 months from now. So even those cases that were in the hopper, and if you dealt with courts around here, I'll say I got a tenant out on a default from a 60-day notice. I forget the basis, but they were out on a default and we granted it. It took the court 6 weeks to get us a judgment.
Yeah.
Take that and multiply it by about 10, and that's like the fast appellate courts. So we are talking about months with the person sitting in the house and doing whatever they're doing. So, and I have all respect for Neil Tardif, but appellate attorneys are incredibly expensive. I did some appellate work in my ignoble youth. It is in a completely separate set of skills. You will almost necessarily need a specialist for that. So if you have an attorney or someone, or the judge says, well, you can just appeal it, that's basically the judicial version of giving you 2 middle fingers and walking out.
Oh gosh. Okay. What about squatters? One time.
Okay. Well, I don't know if we want to stay just on topic. So
Okay.
Or something else.
yeah, let's go like, what do you want to do? Probate? What do you guys like?
Yeah.
Boundary
Partition.
laws? Yeah, partition. Let's get
Partitions.
into partition.
I'm
What's a
probate.
partition?
That's a good question.
Okay.
What's a partition?
So a partition action. So this has been a big part of my practice for the last 2 or 3 years, or 3 or 4 years. I think of a partition as like a divorce. So you can be owning property with other people, and then you decide you don't want to own property with other people. And then what happens is you file a partition action. No one is forced to remain co-owners of property. And that it comes up often in probate, or your father's girlfriend is a co-owner, and then you inherit it. You don't want to be with the father's girlfriend. It comes up in all sorts of strange circumstances. The other one where there was a big, well-known ranching family who they had, all of the heirs had received percentages of this ranch. And then
Are you talking about one of my clients?
Nope. This has been over for a while. And so I would always tell my clients, don't worry, no one is going to buy a 25% interest in property. So you really don't have to worry about, that weird uncle over there. Well, the weird uncle sold to a developer, hopefully not in here. Kind of looking. And then the developer just immediately filed a partition action. So here was this kind of a famous ranch that had been held in. They got their title from the Spanish land grant. That's how it got there. And then it turned into a lawsuit. So I think that's you can no longer do that because they changed the law just because obviously this was happening to other people after my case was done. But what happened is you go into court, you first get an interlocutory judgment as to who has title, and then you decide either you're going to together sell the property and divide the proceeds. You can divide the property if it's big enough into the parcels, into the percentages that each owns, or you can continue to fight. It's obviously best to try and get it resolved. or and in our case, we had a referee who did an excellent job trying to get it resolved. And the real estate agents also really helped to get it resolved. So the good guys won because the family continues to own the ranch, and the investor did get good money out of it. But that it's kind of a partition action that comes up very frequently, and that can actually then you can keep an eye out for disputes that are out there, and perhaps pick up property that you might not otherwise think is a good idea, because maybe you can get an agreement to purchase it without going through the regular escrow process. I mean, there would be an escrow, but marketing process. But partition actions are something to know that they're out there. They're an opportunity to buy, but they're also an opportunity if you decide to buy with other people. There is an out for that if you don't get along with them at the end, after a few years or whatever.
So if it's like, let's say, a standard house or a multifamily building, you can't chop it up like you could a ranch into individual parcels. Do they just pay out your portion of the equity and you move on?
Right. There's one, the best one I ever saw. This is our Judge Reality case. So there's a parcel. It was already divided into two parcels with the same percentage owned by each, and the judge forced it to be sold, which is against the law, basically. But,
Like I said, every time you go in front of a judge, you're
Just
flipping a
don't know.
coin, and it's not even you win or you lose. Sometimes the judge comes up with entirely new ways to make your life miserable.
and we do have an appellate attorney, but then they decided it's just, there's too much money being thrown at it. So I think they're just going to go ahead and sell to a famous company. But that's another situation where it was property that was owned by two brothers, and then the children, and then they don't get along. And so that's how you can get a divorce and real property.
So, is that like a tenant in common type of ownership, or how if they're ticks? I mean,
Right. I mean, you would own it as tenants in common. If you own it as a joint tenancy, once you file the partition action, it would become tenants in common.
yeah. So you can, if you own a piece of property, this guy owns his half of the tenant in common agreement. This guy owns his half, and you don't like him, you can file this petition
Action, which then you either sell the property, one side buys the other one out,
Right.
or you sell the property.
And so, does everyone have the access or the right to do a partition in that arrangement?
Yes.
It's-
Because it's really like being married. You can't be forced to be married to
Yeah.
someone. You can't be forced
Yeah.
to own property.
I have a tenant, or I mean a client that's doing this right now, and it's super helpful hearing kind of from your perspective. Basically, that's kind of what it came down to is the relationship didn't work out. One has to buy the other one out, or they just both have to sell and agree to it. But I think it's like the last straw, or your last option, right? Hopefully, you're just gonna work it out because you're partners. It's like, hey, let's not lose this in foreclosure. Let's just sell it, or
But it's a good remedy
Yeah,
in
it
case
is.
you can't work it out.
Yeah, the best way to think about it is if this person absolutely will not agree to something like a lot line adjustment or the
If you
creation.
can't do a lot.
Yeah. Oh dear God, let's not even talk about the lot line adjustments. Lot line adjustments are if you're either creating a new APN, accessory parcel number unit, so it can be marketed separately and sold separately, or if you and a neighbor have a boundary line that may have, shall we say, drifted over the years. You see these a lot with old fence lines. Sometimes it's actually as simple as a slump. The land is slumped, and so the fence is moved. And if they've been there long enough, you have real estate problems, prescriptive easements, adverse possessions, that fun stuff. Realistically, the first thing that you should think of when you're approaching these things is your pocketbook. Because we're in here to make a good ROI, and principal makes me a lot of money. I know attorneys who don't like to represent clients who are on principle, but I love it. Oh, they make me so much money. Oh my lord, yeah, just holding out for the apology. The apology. I've made $20,000 holding out on an apology before.
Although that's a great way to settle a case, though.
Oh yeah.
If you give an apology, a lot of times people just cave.
Yeah, a lot of people want the apology above and beyond. So if you want to trade, if you're willing to trade a little bit of pride for a lot of money, that's a great way to do it.
But going on with that, if you're buying property that you might want to divide, or whatever your ideas are, be sure you go and make sure that you can do that. Talk to the local county, whatever the agency would be that's applicable, because a lot of people just think that they're going to do it.
Yeah.
And then they get it, and it's for some reason that you can't do it. So there's a huge ranch could not be divided into 3 or 4 parcels because of the zoning.
I know at least in, I believe it's San Luis Obispo and Atascadero, there is a rule regarding subdivisions as being the average size of the plot within like a 3-mile radius. So even if it would pass downtown, or even if it would pass someplace else, if you're in an area with big plots, you just got a big piece of land that you have to deal with now. And also, above all, I said at the beginning, I'm going to say it again, especially with this, get a title report for God's sake. I have a client, let's just say this, if there was any more cloud on this title, this place would just be Seattle. And she knew what she was getting into, looking forward to it, and we were able to negotiate a very good deal. But like all the things, every single thing I warned her about, old tenants coming back and claiming they owned the property, people making transfers that went to a person who didn't actually exist because they spelled their name wrong, and then the person in their real name transferring it to someone else. All this stuff came back to haunt us. And like, this was more or less a tax fire sale. Like it was the best piece of property that you could pick up for the lowest possible price and then flip for a mint. And the problem is that when you can flip it for a lot of money, there's always something wrong with it. And if it's not, then tell me when you see a unicorn, because I'd really like to see one myself. But one of the problems, one of the things I guess I should just segue into probate now. But probate and trust properties can be sort of a good investment opportunity, because a lot of people are passing away or passing on property, and they're property rich but money poor. And so talking to beneficiaries, check the obituaries. It's not just for apartment hunting. And even if it's turnaround funding, because the thing is that everyone wants to be in compliance with, what is it, Prop 34, 43, 19, the proposition which, yeah, it's been changed twice in the last, in as many years, but everyone wants to be able to keep their property tax steady, and that means having an unbroken parent-child transfer of a full interest in a property where they are staying as their primary household. And a lot of these trusts can't get loans. It is a great place to make a little tidy sum for doing nothing more than giving someone money and getting it back 2 weeks later. Because generally, the thing is that one of the beneficiaries has to get paid out the value of the property, and then you have a mortgage on a great strapping piece of property, and they have incredible equity on it. And if you want passive income, that's a great way to do it. I say this a little bit shamelessly because it is an incredible difficulty to find financing for people in these situations. So it is an untapped market as far as I'm concerned. Private money specifically, because banks do not loan to trusts. But for probate, probate is the place that no one wants to be, ever. We're talking about something that'll slow down everything. And realistically, I've been 30, I'm not 30 any longer. I've been invincible. I've known I'm never going to die as I'm driving through 6 inches in the East Bay when the Bay comes over the freeway, and I'm laughing like a hysterical because I'm never going to die. But you need to have an exit plan. I call it your plan for when you're out of town. Because sometimes something comes up. I can't tell you the number of clients that I've emailed while they're in the Mediterranean going, hey, so your tenant's destroying your property and you want to go forward with the unlawful detainer. They go, I don't need a retainer. You need someone to be able to take care of your stuff while you're out of town, because the entire purpose of this is to get money and to enjoy yourself. You need something to be able to take care of yourself while you're out of town, because, you know, tenants can tell. That's when they have the parties.
Or kids.
But the thing is that most people don't even think about it. They don't think about it until it's an end of life. But having, as a successor trustee, being able to put into charge one of your partners, giving them access of the property, or, you know, having a family member do it, it's such an easy way of being able to enjoy the money you're making off of this property. Now, I mean, unless you're inheriting something from parents or a relative, you know, God be praised, you'll never have to touch probate. But probate is a one-size-fits-all form. Probate goes one way. There is no flexibility. The judge is watching over everything. If you want to do, you know, experiments with financing to get it out, judge doesn't care. Judge doesn't care. They are there to put you on a conveyor belt and get you out the other end, regardless of whether you like the outcome. Get a revocable trust, or get an LLC or two for the property. You need to have a way of managing the property when you're out of town, literally or figuratively. Like I said, this is another one of those situations where it's like, oh boy, another person died before they were able to put their property in a trust. That's another $50,000 I'm making. Attorneys are the only people who profit. You can spend $2,000 now, or you can have $50,000 of equity just tossed out onto an attorney's lap for them doing nothing more than pushing papers. That's it.
Good. That was going to lead to my next question, which is asset protection. So let's talk bulletproof asset protection. Like, what's the best way to protect ourselves from liability, from someone trying to sue, from a tenant trying to sue, or someone falling off a roof?
You can.
Yeah, insurance.
Yes. No. Insurance is the best. What I say to my clients is a tenant can sue you if they claim you changed the moon from blue cheese into green cheese, and now their blue cheese venture is not going to work out. You cannot stop people from suing you. You can't. That's just an impossibility. There are two ways to make yourself a less enticing subject. The first is protection. The general easiest way of protection is incorporation. Now, one of the problems with incorporations is people just treat it as a name. They just say, hey, I've hung up my shingle, here's my name, whatever, I'll just, take money out of it. No, that's now your invisible friend. That's Harvey. You're going to want to treat Harvey with love and care as if he's a member of your own family. Because the more you believe in Harvey, the more the courts will believe it. So it's not enough. It's an incredible amount of work. The thing is that at a certain point, there's a sliding scale of how much investment is necessary and how much liability is necessary. The easy answer is to be a good landlord. Be a good landlord, treat your tenants well, make it so they don't want to sue you. If you find yourself in a situation, make sure you have insurance. If you're worried that you've got a big old sore spot or a big old nest egg that they're gonna hammer, incorporate.
You also have to follow all the rules and follow all the forms and all of the maintenance. So I have an LLC and a partnership and insurance. And I hate insurance companies. I hope I don't offend anyone. I hate them. But I also tell people to get insurance because that is going to be the least expensive way to protect yourself. A partnership and an LLC, they're not quite as formal. Their requirements are not quite as formal, and so I've found that they are the better way to go. The LLC, you have to pay like $800 a year or something, but that's still it's very informal compared to a corporation. So I always recommend partnership or LLC.
I was going to ask Anthony, an LLC, single member LLC is acceptable for that level of protection, or can anybody punch through that?
I don't think it's that easy to do, as long as you do everything the correct way. Yeah. Honestly, I don't know.
Yeah. The LLC exists. It is a different person from you.
Taxpaying entity.
Yeah. The thing is that, like I said, shortcuts. Don't. Shortcuts is what makes us money. Because the thing is that it's not enough for me to say you have to incorporate. Because if you don't incorporate right, if you don't treat it right, if you don't put enough effort into it, it's just another thing you pay money out of. I've assisted in piercing a corporate veil at least once because the guy just took the money straight out of the corporation. It was just as easy as pointing out that he's just undercapitalized. And the judges are like, okay, we'll go against them personally. And partnerships, unless it's a limited partnership, you're still a big fat target there for anyone.
Do umbrella policies protect you a little bit more? I know it's not an LLC, but do you like umbrella policies?
Because I think they are a little bit more general, so you might be able to get some coverage. I would have a primary policy covering whatever it is you're doing, but then umbrella policies also, and then they can fight over who's going to pay or defend, but they are the ones that are going to be on the hook. Hopefully, they have a job to do, which is not to pay money, but if hopefully you do have coverage.
And then regarding the LLC, if somebody has ownership or title of their property either in their name or in a family trust, and then to try to protect themselves, they move it into an LLC. I heard, and I don't know if this applies in California or if it's just in other states or something, but I heard that could trigger a reassessment of your taxes. So if you've had a property a long time and you've got Prop 13, you will get reassessed once you put it into the name of the LLC.
There are some ways to get through that, and honestly, if you go talk to the assessor's office, they're really helpful.
I was there today.
They are actually incredibly helpful. They brought me and my clients in around the time the Proposition 19 went into effect, and one of them sat down with us and went through all the guidance they had received, all of the indications, what they believed they were going to apply it to in the future. So if you have any questions about assessment, they're lonely. Just go and talk to them. They will answer all of your questions.
So there is a way to put up your own property in an LLC and not re-trigger property tax reassessment?
I think
there are some, and I think it's individual, but if it's the same people and the same people, I think there are ways to do that. But I would talk to them. It's a
reassessment trap if there's any change in ownership between the original property. And like I said, this is not legal advice.
Yeah.
It's a huge trap. It's a malpractice trap, and it's a huge reassessment trap. Generally, when you even consider doing any of these before you talk to the people in the assessment office, you have to make sure that every single percentage matches up exactly. The minute one of those percentages changes, then you've fallen into that trap, and there's a possibility of an assessment anytime anything changes.
I can give an example of the 50. So we had 2 LLCs on the property, 50% each, and one LLC sold their share to another LLC, and we did get a reassessment letter, but it said we noticed 50% of the ownership has changed. What is the blah blah blah? So we just simply sent them the information, and it wasn't reassessed.
Because it wasn't 51%.
Yeah, basically. But and then also in the other regard, I've had the other thing happen where you're just changing partners. So like as long as you can show your operating agreement and you have a good reason or explanation for the name change, then it might at least help you better. But like you said, it's like a judge. Like you never know who you're going to get at the assessor's office. So
they generally have internal rules, and they'll actually be quite candid as to what the guidelines and the rules are. But you have to talk to them. Don't papering it over. Like I said, papering it over after the fact is a great way to give you a lot of money. So.
What about asset protection against taxation? Like specifically upon there is none.
I don't do taxes. I hate taxes.
Tax law, it used to be the boogeyman for malpractice attorneys around here. It's like you say,
I never liked
you're like, oh, you need errors and omission service. What do you do? Well, I do 2% tax law. It's like, oh, well, your bill just went up 300%. So there are no easy answers to protecting taxation or increasing taxation, except just don't move anything, because reassessment triggers on very specific circumstances which are present in the tax code, and if nothing changes, no one really pays attention.
Well, so that's why my question is like, so say you had, $15 million worth of property and you're gonna pass away, so how are you going to give that to your kids without paying an inheritance tax on it, like by paying it into an LLC, not an LLC, but like a corporation?
That's especially like 15 million or anything like that. I mean, there are people who specialize in that.
Yeah.
Right. I was just curious.
Yeah.
First and foremost, inheritance tax isn't a thing. Inheritance tax is not a thing. There is a gift tax. Basically, don't know how much to joke about this, but it's deeply political. Deeply political. Back in the old days, the lifetime gift tax exemption was about $2 million per person, meaning if you gave anyone more than $2 million above and beyond the $15,000 you can give everyone per year, which I believe is up to $18,000 based on inflation nowadays. This is a talk I give all. Then you begin to pay gift taxes on it. However, Donald Trump had the good foresight to raise it from I think it was $5 million to $13 million. Plus, we have this wonderful thing called portability, which allows you, if you and a spouse own a piece of property and you're transferring it to the kids, you can join your lifetime gift tax exemptions together whenever the last of you passes away, and up to $30 million that you're transferring, I believe, would be tax-free.
Everything over that, though, you'd be taxed at like 42%.
Yes. Generally, there are a number of ways to avoid this. The most boring way is if we're concentrating on specifically avoiding. Reassessment is going to come for us all unless they're living on the property. Period. If they're not living on the property, just prepare for higher taxes. But if you're looking for a way to avoid paying taxes on a piece of property you're passing down, learn to love the $15,000 to $18,000 per year gift tax exemption per person. Meaning if you give it away to 8 people, That's 120,000, 125,000, 120,000. I became an attorney because I took my last class in differential math and I never wanted to see a math problem again for the rest of my life. But you learn to love that. There's a lot of structures you can use in order to transfer property to get your assets below that level. And when we're talking about 8 digits or above, there are firms that specialize in just working on 1 or 2 clients with 15 million or above in real estate assets. There are plans, there are ways of transferring property and protecting it and dividing it. These plans can get very, very complicated. And so in the end, like I said at the beginning, it's all about your pocketbook. How much money are you willing to spend now for the money that your children will save later? Because, and this is one thing that people really get caught up on, is you will never pay more in tax than you will get for every additional dollar. If you go up, it doesn't increase the bracket of every under subsequent bracket. It only increases that. You will never pay more than a fraction of every dollar increasing. I know some people who are so adverse to paying taxes that they'll throw tens of thousands of dollars away on avoiding even a marginal increase. You have to be very, very deliberate if we're talking about estate planning, because it's all about money. It's all about how much do I give up now for how much I get later. This is not legal advice.
Coming back on the eviction thing, so after you negotiate with the tenant, I'm sure you have to put in writing. Do we do it, or we have to hire an attorney to do it?
You probably should have your attorney do it.
And can the attorney also negotiate on behalf of me?
Yeah.
Do confrontational as opposed to anytime you have attorney involved, oh, geez, or more.
It depends on the tenant and it depends on the attorney.
I think I would suggest an attorney just so you don't put in writing the wrong thing. That can get you often into trouble. It probably, I mean, it doesn't need to be anything very formal, but just make sure you're not doing something illegal or contrary to the intent of the law. I can't really come up with something off the top of my head, but I often will have people just they'll send me something and I'll just make sure that it's okay. But often there's something in there that is, could be very, very bad, come back and haunt you. So it's just helpful. You can put it down generally what your offer is, and then just make sure it passes the test.
Do you have to put it in writing, or can it be verbal, the cash for keys?
Well, if you want it to be enforceable, it
Has to
should
be
be
in
in writing. I mean, oral agreements are enforceable, but you have a tenant and a landlord, they're not going to be saying the same thing.
An oral agreement is worth the paper it's printed on, more or less.
So I have a question. I did a COVID relief deal with the tenant that hadn't paid for like a year and a half or something, and so the neighborly software, I guess what they call it. So we agreed, everything seemed fine. They sent me $10,000, and then I got an email about a couple of months ago. They're saying that this was not approved, it was fraudulent, and they want the money back.
What?
Well, this is what's happening, and so I wonder if anybody else
Was
has
that
had
from
that.
the government?
The government or
from
the tenant?
No, from the government. They want it from whoever wants to pay it. But they gave it to me, so that's why they're coming to me for the money. So, and I'm not sure how to fight it, or I guess you can appeal it, which I sent them an email saying I wanted to appeal it, but I don't know how to proceed beyond that.
We'll get an attorney.
But there should be a list of their reasons so that you can defend against it.
You would think
Yeah.
so.
Really?
Generally, it's a matter of communication. If you're not having success communicating with them, find an attorney who can. But the thing is that the government is full of people who are just punching a clock.
Mhm.
And as long as you can have someone who can deal with them, I've always said to every paralegal, every attorney, I'm like, if you're nice to the people in the window, they'll commit crimes for you. This is not an indication of my actual experience as far as anyone in this room is supposed to know. But if you approach them in the right way, because the thing is, they're there to collect an amount of money. There are reasons for every decision. Everything is governed by 3 to 4 rules. And there's always a reason for what they do. And if they're not giving it to you, then it's just a matter of pushing it deeper until you find someone who can release that info.
I can't even get them to, can't even get through on the phone when I call.
That's really, I have not heard that. I've heard people, I mean, they're getting like criminals out there, but not for the landlord tenants.
Yeah,
That's
no,
interesting.
I asked Dennis Block down in LA, and he said that, he's starting to hear that people are getting asked for the money. So,
When did you?
when did it start?
Yeah.
I don't know, a couple months ago.
When did you get the money?
I don't know, a year and a half ago or 2 years, whatever it was, when everybody was getting it.
Yep.
Yeah, it was $10,000.
Yeah,
It
my
was
dad
a
got-
huge amount.
Really?
He got like a similar amount for a tenant that wasn't paying for a year and a half,
Right.
but then he hasn't got asked to pay it back yet. So I'll ask him.
I've heard about this where people are being asked to pay back and they're going after the landlords because you're most likely to have the money.
Well, they're the ones that they gave it to me.
Oh, they gave it to you.
Yeah.
Right,
Yeah.
right, yeah. Yeah, I have heard that
So
they've
you
been.
have, and what have you?
I don't know what the ramifications or like what's ended up happening, but I did hear that they've been asking for it back.
This is all uncharted territory. This is incredibly new. You are on the breaking edge of
Yeah.
the law, and this is why you don't want to be a test case.
Well, I think
Can't
I
get
am.
anything
No matter what, I already am.
Yeah.
Yeah.
There's probably a distinct possibility that the tenants have claimed that they paid when they needed some form of relief. So the federal government's saying, we got paid twice, we want our money back.
Yeah, that
Very true.
No, not this lady. No, she's been super cooperative, and no, I don't think she's the cause.
well, there's
I
a
doubt it
the thing
I don't
is
know.
that
for sure.
how do I put this?
Finally got a household.
Through ignorance, people accidentally commit fraud all the time. So that's not to say it's anything against her character. She may be a sweet lady. She may be salt of the earth. If she's not an expert at something she's doing, something she's filing with the government, it is very easy to just write down whatever occurs to you. Like I said, don't take shortcuts.
But how would she be involved? I mean, it's already over.
Right.
And
And
why
you
is
know-
it she would be communicating with them at all?
She might have applied for some type of financial
Or her tax
Yeah.
return?
yeah, or a return,
Yeah, that's possible.
or it wasn't on your return.
Not mine.
Yeah, so I would keep asking him in writing, what is the basis
Yeah.
of this, so you can prepare a defense.
Yeah.
Because it's hard for you, how are you supposed to know what to defend against
Right.
if they won't say the
Right.
basis?
Yeah, getting just a letter, even if not on attorney letterhead, to the address they say, because I worked on OICs, offers in compromise, with the state government, the federal government, and these are people who the government goes like, oh yeah, you don't have any money, so we want as much money out of you as possible because you know you're never going to pay your taxes. I had to sit on the phone for 4 hours doing other matters while I was waiting for someone to come. I would spend the better part of the day trying to get to talk to someone. So don't rely on getting them on the phone. Send something in writing. If it's important and you want a record of it, put it in writing.
So
Yeah.
not
Always.
email, but send it to
Right.
their address.
I mean, email is
Okay.
good too.
Yeah, that's a good idea.
Yeah, but put it in a regular letter, because you never
Yeah.
know where they're going to go.
Right.
But how are you supposed to prepare a defense if you don't know what the basis is?
Right.
The difference between an email and a letter is because of the fact you're dealing with the government, a receipt from the USPS is considered dispositive.
Mm-hmm.
An email is arguably dispositive because you might have a record of it, but if it gets caught in one of their spam folders, or if someone else deletes it off the computer. There's innumerable ways for that to go.
Yeah. Oh, it makes sense. Yeah, okay.
Faxes are also kept alive by the government.
What's that?
Faxing is also kept alive by the government.
And doctors.
Like we're gonna wrap it up, but you can like they'll probably be around soon. Ask them a question if you want, and then oh yeah.
When she didn't pay, and then send that with the letter and say, hey, no, she didn't pay.
Well, all that was sent when they approved it.
Right.
Doesn't mean that the department that's dealing with you and the department you're dealing with there are the same department.
Yeah, so
As a
send
matter of
it
fact, they're
again.
usually not.
Yeah.
You can never assume that the government agent who's talking to you has all the facts and all
Right.
the documentation. Heck, I've even talked to people in City Hall about ADUs and whatnot. You resend all of the documentation every time you talk to someone. Because I've been transferred from person to person within the same department,
Yeah, no, I
and
got
they've
you.
asked me to resend everything.
So when I send that initial letter, should I send some documentation with it, or just ask
I
them?
Because that
What's
would just
going on?
open up another.
You might not want to send them more information.
Yeah.
Okay.
So I would just,
Yeah,
you know,
just
say,
start
I
with the
do-
letter.
That's
Yeah.
best.
Yeah. Okay.
That's a profit loss thing. If you're going to do it on your own, generally I would suggest you ask very specific questions and you answer. It's the entire criminal law thing, right? You don't volunteer any information because they are looking for cheats.
Mm-hmm.
Because like the I'm sure MSN got like $2 billion in PPP loans because they had to lay off their entire staff.
They might have seen his photo of going to Vegas like the next week and like
That was it.
Yeah, and, like they're looking for cheats. So
But we don't know why you just got.
Yeah.
you won't know unless you ask, and you ask in a way that's immediately determinable and provable.
well, thank you.
Well, everyone,
Yeah.
thank you for being here. There's a sign-in sheet circulating. If you want to get a video copy and get invited to future episodes, the panel. And let's all thank our panel for coming out tonight. Thank you all for being here.